All right, folks, thank you so much for joining us today for Understanding the Fearless Foundation 11th Circuit Decision. My name is Nicole Bronson. I'm the Vice President of Communications and Content at the Council on Foundations, and I am so delighted to welcome you today. Really just to get us started, I want to give you a couple of quick reminders. You can use the Q&A function in Zoom at any point if you'd like to ask a question, and we will sort through those questions and answer them after the first beginning part with the speakers. Just a quick note that the call is being recorded and will be shared with webinar registrants. And if you have any tech issues at all while we're on the webinar, you can email webinars@cof.org. And of course, if you need the live transcript at any time, you can click the live transcript button and select show subtitles. So I want to just walk you through our agenda today. We will be hearing from three esteemed speakers: Dr. Akilah Watkins, who is the President and CEO of Independent Sector; Ben McDearman, who is our Director of Legal Resources here at the Council on Foundations; and Emily Cuneo-DeSmit, who is a partner at Morgan Lewis. Thank you so much, all of you, for joining us today. So folks, to get us started, we will have an opening from Dr. Watkins, then we will go into an overview of the decision by Emily, and then we will open it up for the Q&A. So please, as I said, at any time, put your questions into the Q&A and we will keep track of them from there. And now I'll turn it over to you, Akilah.
Thank you, Nicole, and thank you to the Council on Foundations for partnering with us to host this important discussion today. As you know, almost exactly 1 year ago, the Supreme Court announced its historic decision to end race-conscious admissions, or affirmative action. While this decision was focused on higher education, we knew the ripple effects would soon reach the broader charitable sector. Since then, the Council on Foundations and Independent Sector have been part of a broader ecosystem of partners working to provide insights, analysis, and resources like this webinar so our members and the sector more broadly can adapt and respond. We began to see the ripple effects of the Supreme Court's decision on our sector in August of last year, when the American Alliance for Equal Rights filed a lawsuit against Fearless Fund and Fearless Foundation, challenging one of the foundation's grant programs. Fearless Foundation is a 501c3 organization led by Black women that helps combat underfunding in venture capital by providing grants, tools, and mentorship to women of color. Its grant program, the Fearless Strivers Grant Contest, is for Black female entrepreneurs. The program provides grant funding, tools, and resources. In December of last year, the Council on Independent Sector filed an amicus brief in the case to protect donors' ability to give charitably in ways that align with their values, as protected by the First Amendment, including efforts to support historically marginalized groups. More than 225 organizations have signed on in support. On behalf of both the Council and Independent Sector, we thank you for that support. Last week, however, the U.S. Court of Appeals for the 11th Circuit Court ruled against the Fearless Foundation. The court ruled that the American Alliance for Equal Rights has standing to sue the Fearless Foundation, and that the Fearless Foundation grant program must remain halted while the case proceeds in court. I know many of you here today have questions like, what exactly does this ruling say? What are the next steps? What does the ruling mean for grant making and our sector? How does it fit into the broader landscape of DEI? Our intention today is to provide you with the facts of the ruling and answer some of your questions. I want to thank Emily DeSmit, a partner at Morgan Lewis, who led the development of our amicus brief, for joining us today. Emily will walk us through the ruling, and then we'll take some Q&A together with Ben McDearman, the Council on Foundations Director of Legal Resources. The case is not over, and the decision is not a final judgment on the merits of the lawsuit. As the case evolves, the Council and Independent Sector will be paying attention and sharing what we learned with all of you to help you stay informed. Now, I'll turn it over to you, Emily, to explain the court's ruling last week.
Thank you so much, and thank you so much for having me. I really appreciate the partnership with this entire group in this case and on all of these issues. All right, so I'm gonna, as quickly as I can, walk through all of the important information about this decision so that we can answer all of the questions about its implications. And so, as many of you probably recall, the procedural posture of this case is that after American Alliance for Equal Rights, which is this membership organization that filed the lawsuit, sued Fearless Fund and Fearless Foundation, all the related entities in district court, they moved for a preliminary injunction to enjoin the grant program. The district court denied the motion for preliminary injunction. The district court held that the AAER, on behalf of its members, likely had standing to sue Fearless, and we'll talk about standing in a minute, and that Section 1981 probably applied to the program. Talk about that application in a minute, but that the First Amendment likely protected the grant program, and so the court denied the motion on that basis. And then AAER immediately appealed to the 11th Circuit. So the 11th Circuit was hearing this at the preliminary appeal of the preliminary injunction stage. With the appeal, that appeal pending, the 11th Circuit temporarily enjoined the grant program pending the decision on the appeal. So when the decision came out, the 11th Circuit addressed basically 4 different things, and I'll talk about each of them in a little bit. So first of all, I just want to talk about how the 11th Circuit framed the facts. And I will say, without any other commentary, that the panel, the 3-judge panel that heard this case, with 2 Trump appointees and an Obama appointee. So, and the case, the decision was split along ideological lines. The 2 Trump appointees held that reversed the district court's decision denying the preliminary injunction, and the other judge, Judge Rosenbaum, dissented. So I think relevant to the sector, the court described the grant program as being operated under Fearless's foundation arm. So, you know, in the brief, we really talked about how this was operated by the 501c3 foundation, right? That the Fearless Foundation, the court kind of minimized that, and then talked about some of the rules for this grant contest and some language in the original rules of the grant contest. In the original rules, the rules said, by entering into this grant contest, you agree that these official rules are a contract. And the court really hung its hat on that. So for those who might not know, Section 1981 of the Civil Rights Act, it prohibits race discrimination in contracting. So it was passed post-Civil War. The original intent and purpose of it was to protect the rights of recently emancipated slaves to contract. And so over time, the Supreme Court has held that it prohibits discrimination on the basis of race against any group. So both against and in favor of historically underrepresented racial groups. Okay, so and contracting is defined really generally broadly under Section 1981, but there is no sort of consistent federal body of contractual principles under Section 1981. So courts look to state law contractual principles when determining whether a contract exists so that Section 1981 applies. So the court here, one of the issues that they looked at was, does Section 1981 even apply to this grant program? Because it only would apply if a contract exists. If there's no contract, there's no interference with contractual rights, and Section 1981, the law doesn't even apply. So here, the court was looking at a couple of facts. Like I said, they looked at the original rules, and that the rules said by entering the contest, it creates a contract. It talked about how there was an indemnification provision, an arbitration provision, just some particular terms in the rules it outlined and said, based on this, we're going to determine that there is a contract, there's an exchange of value. And so Section 1981 applies here. And so I'm just noting that because that's particular to this particular program, right? Right or wrong, this is how they determined it. And those were specific facts relating to the rules that they pointed to. So because Section 1981 applied, they then looked at whether the First Amendment applied. And obviously that is where we focused the brief on. And I should actually back up and talk about standing before I get into the First Amendment. So they determined that Section 1981 applied. Really, the threshold question, though, was, does this organization have standing to even sue Fearless Fund? And on that issue, the district court had already said likely that AER had standing, and had already said that Section 1981 likely applies. The court held that the issue of standing, the question was, AAR suing on behalf of its members, associational standing. Its members in the case were not identified even by name, right? So they talked about anonymous business owners, owner A, owner B, owner C. And those owners submitted declarations where they said, they described very generally, I am a business owner and I would have applied for this grant and I was ready and able and willing to apply, but I wasn't eligible because of my race, because the grant program is only open to Black women. And the court said that even though the individuals were not identified by name, by legal name, that the identification of them and description of them in those declarations was sufficient, and that they had sufficiently demonstrated that they were able and ready to apply to the program. So then AAR had standing to sue on behalf of its members. And so I just want to note that, because there have been some cases out there recently that have gone the other way. If individuals hadn't applied for programs, they did not have standing to sue. And so, but in this instance, the 11th Circuit held that AAR could sue on behalf of its membership. And so the court also dealt with this question of the affirmative action defense. So there were a pair of Supreme Court cases in the late 70s, early 80s, where the court held under Title VII, which is the employment anti-discrimination law, that when an organization makes a race-based decision or a gender-based decision to address a manifest imbalance, a racial imbalance in this instance, right? So the argument would be Black female entrepreneurs are underfunded relative to other groups, and this grant program targets that imbalance. And the court has held under Title VII, the Supreme Court in these prior cases, that if you target a manifest imbalance and you don't unnecessarily trammel on other groups, that can be consistent with the law. It wouldn't violate the law. Here, the court said that affirmative action defense doesn't apply into this case because it goes too far by completely barring people who don't fall into this demographic from participating in the grant program. So it says it operates as an absolute bar, setting aside whether that affirmative action defense would be viable at all. It doesn't apply here. So finally, the First Amendment, because I know this is the most sort of impactful for the sector. And this is what the amicus brief was focused on. So there's a long line of cases, right, as we discussed in the amicus brief, that in which the courts have consistently held that when you make a donation, you are engaging in expression. So, and donation or a grant of money is basically an inherently expressive act, expressive conduct. And long line of cases that says when you engage in expressive conduct, your First Amendment rights, rights to expression can trump the application of anti-discrimination laws that would otherwise inhibit what you do. Here, the court, notwithstanding the fact that there was a fairly recent case out of the 11th Circuit itself that dealt with this, the Coral Ridge case, the court basically held that race discrimination, as they described it, right? So making a decision based on race, an eligibility decision based on race, is not expressive conduct. It's conduct that's kind of separated from expression, and therefore the First Amendment doesn't apply, and it doesn't protect the grant program. The court talked about some cases in which the Supreme Court had held that that other First Amendment rights didn't trump the application of Section 1981, not particularly applicable here. And the court talked about in addressing its prior decision in the Coral Ridge case and in the recent Supreme Court case 303 Creative, in which the court held that a wedding website designer's First Amendment rights protected her from having to create wedding websites for LGBTQ plus couples. The court said those instances are distinguishable because race is different. Basically, the court said race is different. So we can't rely upon those cases. And so essentially, it's hard to say if the court had described the Fearless's grant program differently and didn't describe it as sort of a business exchange, whether it would have held that the First Amendment applies. The decision suggests that in all circumstances, that if there's a decision based on race, an eligibility decision, that the court might say that the First Amendment doesn't protect that decision. But in any event, in some, the court said that if Section 1981 applies, as it does in this case, and you are limiting eligibility for a program based on race, then the First Amendment doesn't protect that decision from the application of an anti-discrimination law, because that decision doesn't qualify as expressive conduct, is essentially what it says. So where is this case now? That's it. That's kind of a high-level summary of the decision. What happens now? So Fearless Foundation could petition for en banc review from the entire 11th Circuit. They have another week, I think, to do that. They would have to demonstrate, an en banc review is sort of, it's unusual, right? So they would have to argue that the court has created a conflict with its own prior decisions. And there's some argument for that with the prior Coral Ridge case. Or if they don't do that, the case goes back down to the district court. And because, like I said, this was the preliminary injunction phase. And then we'll have to see what happens at the district court level. And obviously this is just, one 11th Circuit decision. So this is the first decision we've seen about this conflict. And we will be keeping a very close eye on what happens in the case and how it develops and whether it gets back up to the 11th Circuit.
Thank you, Emily, for walking us through the 11th Circuit Court's ruling last week. I've been hearing a lot from folks in terms of, is this really a case about contractual law, or is this a case really questioning DEI and the validity of DEI as an expression of one's values? And I know we're going to get a chance to really dig into some of these questions. And so I really want to thank people who submitted questions in advance. I also want to encourage folks who, after hearing Emily sort of lay this case out eloquently and logically, if they have any questions, to please submit them, because we do have quite a bit of time for you. And then to go a bit deep with folks on some of their questions. But the charitable sector is a powerful force for good, addressing pressing issues every day and strengthening communities nationwide in a diversity of ways. We need to make it easier for organizations and people to give across all dimensions of society and not harder. We are, of course, deeply disappointed by the court's decision last week, and will continue to stand for the right of philanthropic organizations and individuals to give according to their values, including by supporting historically marginalized groups like the ones we're talking about today with Fearless Foundation. Now, I want to turn to both Emily and Ben to answer your questions. We have about a half an hour for Q&A, and we have a long list of questions here. Thank you to everybody who submitted them in advance. If we don't have time to answer all the questions today, we're going to do our best to get through as many of them as possible. So we're going to go ahead and get started. Here's some here's some questions that were submitted earlier. Emily and Ben, can you describe how this decision fits into the broader pattern with what's before other courts? You did sort of reference other cases. What's recently been ruled on? How is it the same? How does it support this decision? How are those recent court cases different from this decision? And if you could talk a bit about the implications of those decisions.
Sure. So I think we've all been paying very close attention to this decision because it seemed like it was really the first one directly challenging a grant program following the Harvard UNC decision. And for those who may not know, AAER, the plaintiff in this decision, is led by Edward Blum, who's the same individual who led Students for Fair Admissions, who filed those Harvard UNC affirmative action cases, right? So even before Harvard UNC, there was a group of cases challenging racial equity programs, corporate philanthropy programs under Section 1981. Those cases were pending. So this wasn't the first entirely, but it was the first real notable one post Harvard UNC. And we have seen others since, other grant programs challenged by AAER, and another organization, America First Legal, has challenged grant programs in other jurisdictions across the country. This is the only one that we've seen on these particular facts to reach a 11th Circuit, to get a circuit court decision on the particular conflict between the First Amendment and the application of Section 1981. We have seen some helpful decisions on standing, though, that I think are important to note. So we had a helpful decision in a district court in the Sixth Circuit where there was a lawsuit challenging another grant program, that grant program for Black-owned trucking businesses. And that court in the district court in that decision, which is only about a month ago, held that the individual in that case didn't have standing to sue. Didn't have standing because hadn't applied for the program, and the program has since closed, can't show able and willing, ready to apply. That decision's on appeal to the Sixth Circuit, but that's sort of a better standing decision. Another similar decision in the Ninth Circuit, challenging a diversity grant program. Again, those individuals hadn't applied to even kind of either reach the threshold question of becoming a potential supplier for the organization that operated that grant program, couldn't establish standing. That is also going to be on appeal. But I think it's important to note, and then we had a Second Circuit decision where the court held that individuals who had similarly sued under pseudonyms, not naming themselves, couldn't establish standing, and after discovery on that issue. And so it is important to kind of keep in mind standing, and a program that has been completed, it's going to be much harder for someone who never applied to establish standing, right? And because a lot of these cases are reverse engineered, right? So they're organizations finding plaintiffs to sue. And so those have been helpful decisions, but not on the merits. And then we have seen some cases resolve where the organizations are challenging grant programs or organizations and alleging that those grant programs or organizations were race exclusive. And in fact, they weren't, just because they were sort of created to try to benefit members of certain underrepresented groups. They weren't actually limiting eligibility on that basis. And so those cases have been resolved. And then we're seeing more filed, right? So this probably may embolden these organizations to file more cases, but that has been what we have seen, some helpful decisions on standing so far, but this is really the first one we've seen on this particular question of the application of the First Amendment.
Thank you for that, Emily. Really quick, we've talked a lot about race, cases that are looking at sort of race as the sort of organizing principle, right? What about other, protected classes? We want to look religion, national origin, gender. disability. Do we see them as in the same way as race? As we think about sort of programming or the legal implications?
Yeah, so that's a great question. We get that question all the time. The lawsuits that we have seen have been filed under Section 1981 for the most part. And as I said earlier, given its history, Section 1981 is limited to race, race, national origin. So because it was originally enacted to protect Black Americans. So it doesn't apply to contractual decisions based on gender or religion or disability or sexual orientation. And so we wouldn't see lawsuits filed under Section 1981 challenging those programs. There really isn't an equivalent. Of course, we have employment anti-discrimination statutes that apply to all those categories. So if there's an employment program or a fellowship program that's employment-like, you might see a Title VII claim. But there isn't really an equivalent of Section 1981 that applies to those other groups. And so we haven't seen that. I can't rule out that we wouldn't see action and other efforts sort of at the state and local level to inhibit activity. But in terms of a law that these organizations could actually sue under to challenge programs in the way that they've challenged the Fearless Foundation's grant program, there really isn't one. The only caveat to that, I will say, the Constitution, right? So like, if you're a public, if you're a government, obviously there's the Equal Protection Clause, and there are various levels of scrutiny there. But in terms of private foundations, and Section 1981, it's limited to race.
No, thank you for that clarity. Ben, this one is for you. What advice or best practices would you recommend for foundations that work on behalf of racial equity and justice and want to continue doing so?
Sure, great question. I think first of all, want to stop and highlight the fact that we're talking about the 11th Circuit here. So we're not talking about a decision that applies to the entire country. We're really dealing with 3 states. Alabama, Florida, and Georgia are the states in the 11th Circuit. For organizations that are not in the 11th Circuit, it certainly, I think, is really important you pay attention to what's going on here. But remember, we're dealing with a decision at the 11th Circuit level. This does not apply nationwide at this point. As with even before this decision, I think one of the best potential defenses that you can have as an organization that is engaging in work that's focused on racial equity is, if you're worried about a potential lawsuit under Section 1981, as Emily just said, we're looking in those cases at claims against, that make the claim of contract discrimination on the basis of race. If you can take steps to ensure that your program, your grant, that the language that you use when you are creating that relationship does not rise to the level of a contract, that is, I still think, one of the best ways to ensure that you are not going to end up successfully sued under 1981. Certainly, we understand that there are situations where that may be more difficult for some foundations to avoid contract-like language, depending on the nature of the work you're doing. But I think that's a really good place to start, is look at everything that you are requiring of your grantees, look at your communications with those grantees, and find ways, if possible, if you can do so and still achieve the objectives, if you can do so without putting your organization at undue risk in other ways, if you can remove things that might appear to create a contract, I think that is a really good place to start. And then beyond that, I think if we're also looking at, are there ways you can have the same impact on the same populations without explicitly saying we are excluding people based on race from eligibility from the outset? At the oral argument stage, back at the end of January, one of the judges who actually ended up being in the majority here, so they sided with the plaintiffs. He did ask of the attorneys representing the plaintiffs a question that said, essentially, if instead of saying this grant program that Fearless Fund is running was limited just to Black women entrepreneurs, if instead it said something like, we're going to be granting to the applicants who show that they would do the most to support Black women entrepreneurs. If that was the way it was framed, would this still be illegal? And the attorney for AAER admitted, yes, that would not be a violation of Section 1981 in all likelihood, the way that that's framed. It's not saying we are excluding anyone from eligibility based on race. So it's looking more, he said it's looking at the outcome as opposed to that decision from the beginning of we are going to say only this group is eligible to receive grants under this program.
Ben, thank you for that nuance. And there is a follow-up question to that. So for foundations that are hosting leadership development or grant-making programs within Alabama, Georgia, or Florida, areas covered by the 11th Circuit, and they want to exclusively support leaders of color within their programming, can they continue supporting leaders of color with their program, or should they stop supporting leaders of color in their program?
I think, again, you're going to want to look at the specifics around how that is framed. Because again, I think, at this stage, it seems like the programs that are at the most risk of being sued are those that are really exclusively for specific groups of individuals based on race. And again, if you can even take that first step of saying we are going to eliminate the possibility of a lawsuit under Section 1981 by removing any contract-like language from that program, that would be another way to potentially avoid this. So I think certainly if you're in the 11th Circuit, you really do want to pay close attention to this ruling, just given that it does suggest that a program that excludes somebody based on race that is clearly a contract, through a grant program is likely going to be challenged under this precedent. So I think that's kind of where we would stand for that. If you are, and the other factor there I think was for programs that operate out of different states but request and accept applications from nonprofits in those states. I think you want to look at those as well. Look where your activities are. If you're going into those states and you're pursuing potentially granting to organizations in those states, I think it warrants some additional due diligence too. So I think that's really my recommendation for organizations in or operating within the 11th Circuit states. Thank
you. Emily, this question is for you. And Ben, please weigh in. What does it mean in light of this court decision? What does it mean for organizations like the Black United Fund, Hispanic Community Fund, Jewish funds that have been around forever? Are they in risk? And most of them operate within the jurisdiction of the 11th Circuit.
Yeah, I think the question is, can somebody show it? I think we have to separate the mission from sort of the action that would potentially be challenged here, right? Because it's based on these facts, this is one decision limited to a certain set of facts. And to the extent that those facts exist in other circumstances, that analysis and holding might extend to those similar circumstances. But the question in every case is going to be, can an individual show that they were ineligible for a particular contract? And a contract can include things like a loan or an investment, and maybe something that would otherwise be described as a grant, depending on how it's constructed. Can somebody show that they were ineligible for that based on their race? So you can have a fund or you can have an entire organization whose sole mission is to support individuals from particular racial groups or religions or backgrounds or ethnicities, as long as you don't have any programs where someone could make that claim. If you want to look at not what is your mission, but what are you doing? What are your activities that you engage in pursuit of that mission? And what is the likelihood that someone could show that particular? And in the 11th Circuit, right, the court has suggested that, the 11th Circuit would hold that if you are in creating programs that would create contracts, the First Amendment isn't going to protect that. And so you need to look closely. But again, there were particular facts in that case. And so if you're really giving money away, no strings attached money, like that's the sort of the extreme side of it. Giving money away, not asking anybody to sign anything in return, whatever. There's not going to be any contract, and Section 1981 is going to apply. But of course, you know, you have to look at the facts and circumstances as to what's the likelihood that law would apply, and what's the likelihood that someone could show that they're excluded based on race. And then it doesn't really matter who you are, it's really what you're doing. And that's the question. And we can't say, okay, then that's definitely unlawful, but that increases the risk, of course, particularly in this circuit.
Now we're talking a lot about contracts, grants. Really quickly, Emily or Ben, can you say for our audience, what is the difference between a grant versus a contract?
Well, that's a very good question. You know, I think as I said, Section 1981, the law itself doesn't say, here's how you decide whether there's a contract. So the courts in each jurisdiction look to the body of law, contract law, to make that determination. They apply, you know, state law contractual principles, and it's fact sensitive. The primary question is there an exchange of value? So when you're talking about a grant program, is the grantor receiving something of value in exchange for the grant? Or is the grantee agreeing to certain conditions in exchange for receiving the grant? So like I said, in Fearless, they look to the original rules that had since been changed, and the way they described a contract existing with you know, participants. And they looked at the indemnification provisions. And so we can never say in any circumstance, okay, a court's not going to find that a contract exists, but you're looking at things like that. You know, let's look at our grant materials, our award letters, our whatever we do to memorialize, and what are we asking, if anything, of our grantees in exchange for this award. And you know, the more we ask in terms of conditions or something in return, the more likely a court would find that a contract is going to exist.
Yeah, and I think it really is important to reiterate that, you know, just because you have always set up your contracts, or rather your grants as a contract, it doesn't mean that in some situations your foundation might find it is possible to reframe that in a way that does not create a contract. So I'm aware of foundations who their default approach is, when we make a grant, we include language that clearly establishes a contractual relationship with the grantees. They know that, the grantees know that, everyone is on board with that. I'm also aware of some foundations where I don't know that they have ever really considered whether or not it's actually a contract. They include language in their grant agreements and they refer to it in a way that might create a contract. But I don't know that that's necessarily the intention of all the parties when they go into it. It's just that is the form that their grant agreements take. And then finally, there are foundations who clearly are not granting money under a contract. They are, I think, especially in recent years, you see more of this, the trust-based philanthropy approach, where you say, we have vetted you as an organization, you the grantee, we trust you, we believe in the work that you're doing, we're going to give you this grant and kind of get out of your way. We're going to give you a general operating support grant because we think that you are able to decide how to use this in a way that furthers your work. And we're not going to require a lot of hoops for you to jump through as a part of this. And I think those are really, in all likelihood, not going to be interpreted as contracts in most cases. So just, it's important to remember that that is a great tool for working with grantees, where you know they're doing work that you support, you're familiar with them, you're not worried about them misusing funds or really having to show, you know, we are using these in a specific way. And then looking at the language that you use to memorialize those grants, removing things that would cause those to be interpreted as a contract.
So we have tons of questions keep coming in. My question is, you know, this feels very strategic, right? Like going after the 11th Circuit Court, especially after the affirmative action decision, but the Supreme Court, you know, what can we expect next from the American Alliance for Equal Rights? What would be sort of a logical next sort of strategy for them as, you know, as sort of more dismantling legally happens around this issue.
Yeah, I mean, don't quote me, it's hard to say for sure. But I think when the Harvard UNC decision came down, we all were saying it's important to remember that this is limited to higher education, but without a doubt, it's going to lead to more challenges. It's going to embolden this, these groups. And I think that's definitely true here, right? We've already seen other cases filed in the Fifth Circuit, in other conservative circuits, in the Sixth Circuit. We should expect that to continue. I don't know if this is a situation where so far we've seen challenges to grant programs where the eligibility criteria is admittedly, right? There was no question in this case that you had to be a Black woman to apply for this grant program, right? So will we see more challenges to other grant programs where it doesn't say in the application you have to identify as this member of this racial group to apply, but challenging programs that look like maybe there's favoring of certain races in the process? We might an effort to expand the reach of this decision. I could see that. So I don't want to say for sure, but I think that we would at a minimum expect to see more cases and try to get additional conservative circuits to kind of look at this decision and apply this analysis more broadly across the country.
So there's a question that comes out about ethnicity. We talked a lot about race. Would this be challenged in the same way if, let's say, this was a venture capitalist firm for Hispanic women?
Likely, yes. I mean, I think in terms of, there's some nuance there in terms of how you kind of describe the eligibility, but we have already seen other cases challenging programs for, and I think the eligibility or the alleged eligibility was based individuals who identify as Latino under Section 1981. So I think it's race, national origin, which would kind of apply across the board there, as opposed to the other categories that we mentioned earlier, like gender and religion and disability and sexual orientation.
Yeah, absolutely. Ben, I want to just check in with you to see if you had anything to add.
I agree with that on the Hispanic question. I think that is likely how we'd probably see that brought under 1981 as well.
So this question keeps coming up about collecting data, demographic information about grant applicants. One of the ways that the sector has wanted to be more transparent is to really look at demographic data of their grantees, of their constituents, their boards, that sort of thing. Do we see any challenge to that? Is it still safe to collect demographic data about grant applicants?
I think so. I think the issue, of course, and this was the case before, this decision, was being careful about how you use it and how you represent, this data is being collected and for what purposes. But certainly the idea that an organization can't know information about its grantees and use that for especially evaluation purposes, I think is really taking this and related rulings to too far of an extreme. Yeah, I think it would be very difficult for an organization to say that they know how they are achieving their mission, if their mission is, for example, focused on the impact they're having on racial groups. If you don't have the ability to know who or what the the demographics were of the groups that you are granting to, or who the populations they're supporting, there would be no way to tie back your grant making efforts to any particular results. So I think, again, there would be challenges potentially there if somebody were going to say, it looks like, they are collecting this information, and based on the way that this grant program is really being handled, we think that there is some behind the scenes discrimination in the process. So I think that's where, if you're collecting demographic information solely for evaluation after the fact, being very clear about that and making sure that your internal protocols for how you manage that data is clearly understood and documented. But yeah, I think just like organizations should not view this as saying they can't collect demographic data for evaluation or for other basic, internal purposes that aren't necessarily related to the decision-making process. And again, even with respect to decision-making, there still is nothing that I read from this to say that broadly you can't use that as some factor in your decision-making. It's really just, the court here is saying you can't use it as an absolute bar for eligibility in the first place. So I think that's an area where it's still somewhat unclear exactly where you would draw that line.
Thank you, Ben. Emily, there's been a lot of questions in the chat about, was the First Amendment the right argument for the case? There are some others that are suggesting about talking about the access or lack of access to opportunity being sort of the legal framing for the case. So using Fearless Foundation, racism, classism, sexism, these are all barriers to venture capital. And maybe that would have been a stronger argument as opposed to using the First Amendment. And so love to get your thoughts on the validity of the argument, the actual legal scaffolding of this case. And do you think there could have been other stronger arguments to be made?
Oh, I actually think it's really important to emphasize that those arguments were made in this case and are being made in this case. So, and when I say those arguments, I mean that is like, so this sector, obviously, the council and the Council on Foundations and Independent Sector filed an amicus brief on the First Amendment question in particular, because of the interest to the sector in protecting that First Amendment right to make donations, right? But Fearless Foundation in their briefing and with the court emphasized the disproportionate lack of access that Black women in particular have to funding and to capital, and to the fact that this program is designed to address that. And like I said earlier, there was the affirmative action defense, which is that when you make decisions, when you create programs, what you're trying to do is actually remedy the effects of racism, right? And that's consistent with the history and purpose of Section 1981, right? It's furthering that goal of that, the reason it was enacted. All those arguments were made. I want to emphasize that. The only issue that the district court said, or the only basis that the district court denied the preliminary injunction in the first place, was the First Amendment. So that was the primary issue on appeal. And I think, in Harvard UNC, there was the affirmative action cases. There was a lot of discussion by the court about how it doesn't matter if you have good intentions, essentially. I mean, I'm summarizing, right? But your motive to remedy historical discrimination. In fact, the court said explicitly, trying to remedy the effects of historical discrimination is not a compelling enough interest to justify race-based decisions. And that was the Supreme Court's holding. So even though all of these arguments were made, that the court has the Supreme Court in the affirmative action context kind of rejected that as an argument to justify these kinds of programs. And so I wouldn't want anyone to think that that's not the framing in the case. It's just that on the amicus brief, we were addressing one specific issue, and there were more than a dozen amicus briefs filed in support of Fearless Fund that addressed all those other issues as well. So it was sort of a convening of different sectors and different interest groups addressing all of those other pieces.
No, thank you for that, Emily. And I think that clarification is really, really helpful. now somebody, okay. Ben, a question for you for the sector is, how do you think in any way the sector has to change or will change as a result of this decision?
Well, I think, it's certainly important not to take this as bigger than it needs to be. We are still talking about one single circuit. The sector itself, I think, has always had a wide variety of approaches to dealing with the issues that are important to donors and to organizations, and I think we'll continue to do so. I think you will see, some organizations that are, especially those who have the resources, they are not particularly worried about, the cost of litigation. They might say, look, this doesn't apply to us. We're going to keep doing what we're doing. Essentially saying if somebody wants to come sue us, they can do so, and we can, figure out whether the facts in our situation will yield a different result or the same result in our jurisdiction. But I think there are others that, some organizations just tend to be more cautious. They are likely taking steps to either, like I said earlier, at the very least reviewing to make sure this isn't a contract, taking out language to essentially remove some of that risk there, reframing things that were previously limited based on race to being more broadly, either stating a preference but not an outright limitation, or otherwise reframing the context of who is eligible, maybe similar along the lines of that language that was from the oral arguments that I mentioned earlier, where the question was, if we didn't limit it just to Black women entrepreneurs, but we said what applicant would do the most to advance the interests of Black women entrepreneurs. And so taking those sort of steps to say, we're not going to stop doing this altogether, but we're going to, play it safe, and essentially take some of the targets off of our backs. And then again, there are likely some other organizations that are very cautious. Their legal counsel may be telling them, you really need to stop this work altogether. I think that's probably not the case for most. I think for a lot of organizations for whom racial equity work is really a core part of their mission, that is not, that's not an option for them. And rightly so. They're going to look at ways they can continue to fulfill their mission without risking, somebody suing them. But of course, we know, it doesn't take a lot these days for somebody to try to, as we've said, there are people who are finding plaintiffs to try to, back engineer some of these lawsuits. And we certainly expect to see more lawsuits filed in different circuits as people kind of gain momentum here. So don't want to be overly naive about where these things might go, but I do think that you're going to still continue to see a pretty wide range of how organizations are dealing with the risk here. And I don't think this decision by itself significantly reframes that risk analysis for most organizations, at least not yet, just because of the fact that it is, it's limited to the 11th Circuit. It's on a very specific set of facts that, many organizations, grant programs don't look like this. And I think that's worth taking into account too.
So we are almost at time. I really want to thank our guest, Emily, Ben. Thank you so much for taking the time. I mean, we had so many more questions, and we know that this topic is going to continue to evolve over time. I just want to sort of hold any space for any last minute comments you have for our audience. We had over 1,000 people sign up for this webinar and over 700 that attended this afternoon. So any last comments or words?
I would say I think Ben summed it up really well, right? We don't want to overstate the risk, but I think what's really important is to understand the court's thinking here, because while this case doesn't necessarily apply outside of the 11th Circuit, we now know how this particular court thinks about this issue, and the way that the court analyzed the issue was very, very consistent with some of the ways in which these organizations have argued the court should be thinking about the First Amendment. And so at a minimum, if you're engaged in grant making, racial equity programs, you want to be thoughtful about, are there ways that we can reduce the risk that Section 1981 would apply, and without actually impacting our operations? Are there different ways that we can do things? And just being informed, because I think we would likely see other courts sort of follow this. And it's all about, I mean, I say this all the time, but like reducing your unnecessary risk without actually impeding the way that you do the work. And then just to keep an eye, because we are going to see a lot more, additional developments in other jurisdictions too.
Thank you.
I
Ben?
agree with all that. And I think, it's really encouraging to see that we had so many people sign up for this webinar. There's clearly a lot of people in the sector paying attention to this. And that's great. We would not want to be in a position where we are talking to a very small room and trying to say, hey, can you guys get the word out to your peers and let them know this is something they need to be focused on? Clearly, there is a lot of attention being paid to this already. And that's a big step, I think, in making sure that the sector continues to do the work that it has been doing, that it is able to learn from what others are doing, that there is a big community here in the philanthropic sector and the nonprofit sector more broadly that's looking at supporting itself and the people within it to continue doing their work. And so that's really encouraging to me to see that. And we're going to continue to monitor this at the council and independent sector and other organizations. And we'll have other opportunities to let everyone know this is what you need to take away from this particular decision or this development, so that as those risks shift, as decision making may need to take certain new factors into account, organizations feel prepared to do that. But we don't want people to just jump to conclusions and make decisions based out of fear. That's really how we end up with a chilling effect that I think would be really uncalled for at this point, and we certainly would not want to see that happen.
Well, I will say on behalf of the Council on Foundations and Independent Sector, we would like to thank all of our guests today for this very informative conversation, and to all of you who attended and to learn more about this case and how it impacts our work. Nicole, please bring us home. Thank you.
Thanks so much, Akila. Yes, just thank you again for joining us, for all your amazing questions. You can check your email next week for a link to the recording, and obviously we will continue to provide resources as we continue to monitor the case. Thank you so much, everyone.